just quickly, if you're hitting a point where it's probably mentally starting to get to you, okay? Good, it should be. If you care, it should be at this point, okay? If you need anyone to just talk to, or just you want to vent, I prefer not to talk, you can just let it out. Shoot me an email, I'll give you my phone number if you already don't have it. Dean Singer, also available. Talk to somebody you're comfortable with, or just need a release, okay? Today you might benefit a lot from the lecture. And what I mean by that is Leah is going to give you, I mean, as direct as she possibly can, what you need to know about the business entities portion of the exam. Likely, where's this part, if it shows up, going to be? Florida, multiple choice, okay? Like, if that's where it's going to come, that's where it's going to be. And the questions are completely random, okay? And so if you can commit, well, how many pages do you have now? It's like 50 or less?
41.
Yeah, so less than 50 pages. Do the best you can. Most people don't really love this area, but if you can kind of commit this stuff and then say, okay, I think I can master what's within these pages, you're going to be well prepared for this part, okay? Before she starts, and she's pretty direct and quick, it's only going to be like an hour and a half, so.
Yes, it is. So I'll do a break. Hi. As he was saying, I don't spend a lot of time on kind of the crazy portions of business entities, because I mean, if they come up, there'd be a question, and I put a lot of time into like blue sky laws or something if it's not likely to come up that way. So we're just going to kind of roll down through, and I tend to talk fast. I'm aware of it, so if you need me to slow down, just let me know. I won't be insulted. I know it happens. Okay, so the first thing that you're going to see in your outline here is a comparison amongst the business entities. I'm not going to go through that table, but it kind of gives you just a quick outline of the differences and similarities. So let's jump into corporations. So a corporation is a separate juridical entity.
A what?
Separate juridical entity. And what separate juridical entity means is the corporation is separate from its officers, directors, and shareholders. In order to begin its corporate existence, the incorporators must file the articles. So must file the articles with the Secretary of State. Corporate existence begins upon filing. If a person acts with actual knowledge, again, if a person acts with actual knowledge that the articles of incorporation have not been filed, he is jointly and severally. He is jointly and severally liable for all liabilities incurred while so acting, unless the third party also had actual knowledge that the corporation had not been created. Most of the times when I see them test this, they are testing it with a third party who also has actual knowledge. Okay, so just kind of keep that in mind. Okay, the incorporators are one or more persons who deliver the articles of incorporation to the Secretary of State for filing. The articles of incorporation must contain. I would memorize the mandatories, and anything that's not on your memorized list of mandatory provisions is discretionary. Okay, so the first mandatory provision is the corporate name. The corporate name, which must be distinguishable from other corporate names. The name must contain language indicating that the entity is a corporation, may not imply any illegal purpose, and may not imply a connection with a state or federal agency. Right now, with the legalization debate, there's a lot of people trying to file start LLCs and corporations built around legalized marijuana. The Secretary of State is rejecting all of those filings. So that would be a contemporary place for a question to arise, okay, because it implies an illegal purpose, at least at this point in time, with the legislation that we have in the state of Florida. The next mandatory provision is the address of the initial principal office. Next is the number of authorized shares. Then preemptive rights, and if you follow that down to the footnote, although the only opt-in provision mentioned in this section of the Florida statutes is preemptive rights, cumulative voting and par value are also opt-in provisions. meaning that if the corporation has them, their presence must be noted in the articles of incorporation. Next are the address and name of the initial registered agent. And finally, the name and address of each incorporator. So it's not a terrible list of mandatory provisions. So the next are the discretionaries. The articles of incorporation may contain, first, names and addresses of the initial directors. Second, a purpose statement. Third, provisions regarding management, corporate powers, par value, and any liability of shareholders for the debts of the corporation. Now, ultra vires, or ultra vires, depending on who you had for business entities, under Florida law, a corporation can be formed for any lawful purpose. Further, except under very limited circumstances, the validity of a corporate act may not be challenged as being beyond the corporation's power. So corporate action may be challenged first by a shareholder to enjoin, the action. Second, by the corporation itself against a current or former officer. And third, by the Attorney General to dissolve the corporation or enjoin the action. So notice for shareholder relief, your only relief is injunctive, right? All right, so powers. A validly formed corporation has all the powers of a natural person. This includes the right to sue, lend money, make charitable contributions, or make political contributions, limited, of course, by campaign finance limits. They seem to ask periodically about the corporation's ability to make political contributions. Florida statute specifically authorizes that. Charitable contributions may be made for, among other purposes, public welfare, scientific, or educational purposes. So next, let's consider free transfer shares and free transferability. The ownership interests of the corporation are divided into shares. The shares are the units in which the proprietary interests in the corporation are divided. The number of authorized shares, which is also one of the mandatory provisions in your articles of incorporation, right? The number of authorized shares is the total number of shares that the corporation is authorized to sell. So authorized shares are shares issued and unissued. The number of issued shares is the number of shares which have been sold. So issued shares equal shares outstanding plus treasury shares. Next, the number of outstanding shares. So the number of outstanding shares is the number of shares which are currently owned by the public. Finally, treasury shares are authorized and issued but are not outstanding. Now, I really simplified an example here, but if you look at all of the sample questions that test this concept, you can pretty much break them down into the same kind of simple terms. Corporation X has 500 authorized shares. It sold 300 shares on 6/7/2014, reacquired 200 of those shares on 6/15/2014. It then sold 100 shares on 6/30/2014. So how many shares are authorized? It's going to be 500. It's given to you in the facts of the question. How many shares are issued? That's going to be 400. Right? It's the number of shares which have been sold. So we had an initial offering of 300 and then another 100.
I'm sorry, can you repeat that?
Sure. So we have 500 shares authorized. Again, that's given to you in the facts of the question. And it always will be. They have to tell you the number of authorized shares. So how many shares are issued? And you remember the number of issued shares is the number of shares which have been sold. So we sold 300 shares on 6/7/2014. And then we sold another 100 shares on 6/30/2014. So 400 shares have been issued. Okay? How many shares are outstanding? We currently have 200 shares outstanding. Right? We're going to get to that 200 by taking the 300 which were initially sold, buying back 200 of those, and then selling an additional 100. Okay? You all good there? Okay. And honestly, if that kind of question comes up, don't let the facts complicate it. Because it really just comes down to when in time things were sold and reacquired. So next, a corporation may have classes of shares. Each class must be distinct. All shares in the class must have identical preferences, limitations, and relative rights. There must be at least one class of shares with unlimited voting rights. So unlimited voting rights. And at least one class of shares with unlimited economic rights. What we mean by unlimited economic rights are the rights to receive the net assets upon liquidation. So shares may, but do not have to be, evidenced by a certificate. If a share is not evidenced by a certificate, the issue must be accompanied by an informational sheet. The informational sheet must set forth, first, the name of the issuing corporation, second, the name of the person to whom issued, third, the number and class of shares, and fourth, if the corporation has different classes of shares, the designations, relative rights, preferences, and limitations must be summarized on an informational sheet. So our next corporate characteristic is free transferability. Free transferability generally indicates an ability at any time to sell one's shares. However, a corporation can restrict the free transferability of shares, but the restriction must be conspicuous. It must be conspicuous on the certificate or info sheet which accompanies the shares. And by conspicuous, we mean a different font, or italicized or bolded. I guess a different typeface would be okay. So an example of a restriction, could be that the purchaser may not sell within the first 6 months of acquisition, or that the corporation or other shareholders have a right of first refusal to purchase the proffered shares. A purchaser for value will not be bound by a restriction of which he has no notice and which was not stated on the certificate or info sheet. I kind of make a star next to that. They seem to test it a lot. Our next consideration is preemptive rights. And remember, back to the beginning part of this lecture, if there are preemptive rights, they must be set forth in the Articles of Incorporation. So the presence of preemptive rights must be contained in the Articles. Preemptive right is a right to maintain a proportionate amount. So the right to maintain a proportionate amount of unissued shares upon their issuance. The preemptive right may be waived. A waiver, if in writing, is irrevocable, even if there is no consideration. That's also commonly tested, because they want to lead you down kind of a contracts type analysis where you're looking for consideration.
I'm sorry, can you repeat certificate and after that?
I'm sorry, where?
Where it says, was not taken on the certificate / information.
Yep, the next is preemptive rights. Sure. All right, so even if otherwise available, a shareholder does not have a preemptive right to purchase first, shares issued as compensation. Shares issued as compensation, or shares issued for consideration other than money. So let's think about shareholders for a few minutes. Shareholders are the owners of the shares of the corporation. Shareholders can purchase their shares for any consideration, including money, promissory notes, services performed, future services if evidenced by a written contract, or other securities of the corporation. When this type of question comes up, be careful with the future services as well as the promissory notes. Those seem to be the two places where they're trying to trip you up a little bit. Just always remember, if you're talking future services, you must have a contract. Okay. Next, the board determines the adequacy of the consideration received. And
Sorry,
sure, the board of directors determines the adequacy of the consideration received. So essentially, if you're talking about the adequacy of consideration, you're not really talking about money or promissory notes, right? You're talking about the valuation of services performed or future services, evidenced by a written contract. Okay? Next, shares may be acquired by subscription. So shares may be acquired by subscription. A subscription for shares is irrevocable. A subscription for shares is irrevocable for a period of 6 months, unless the subscription agreement calls for a longer or shorter period, or all subscribers agree to revocation. So that's unanimous, right? All subscribers have to agree. Okay. To be enforceable, a subscription agreement must be in writing and signed by the subscribers. Shareholders may receive distributions. A distribution is a direct or indirect transfer of money or other property, except the corporation's own shares, or the incurrence of indebtedness by the corporation to or for the benefit of the shareholders. order to make a distribution, any distribution must be authorized by the board of directors. And the record date,
The what?
record date,
The record what?
record date,
Date?
yeah.
Like, is it?
The record date for any distribution is the date the distribution is authorized. So a record date is the date on which the corporation determines the identity of the shareholders and their interests. There are two tests for making a distribution. The first is the equity and solvency test. Equity and solvency. And the equity and solvency test demands that the corporation must be able to pay its debts as they become due in the regular course of business. The second test is the balance sheet test. And the balance sheet test requires that the total assets must be at least equal to the sum of the total liabilities plus the amount needed to satisfy any preferential rights. And remember that you're not always going to have preferential rights, but if you do have them, they have to tell you that in the facts. A share dividend, top of the next page, a share dividend is a distribution of shares on a pro rata basis and without consideration. A share dividend is not required to meet either the equity and solvency or balance sheet tests. They tried to lead you down an analysis where you want to apply one or both of those tests to a share dividend. You're never ever going to. Okay, so just always remember if they're distributing shares of the corporation, you're not thinking about equity and solvency or balance sheet. Okay, next let's think about shareholder meetings. An annual meeting may be held in or out of the state. And a special meeting is limited to the purposes set forth in the notice of the meeting. Now, the notice of the meeting must be given at least 10 days, but not more than 60 days in advance.
Can you repeat that?
Yep. Notice of either an annual or special meeting must be given at least 10 days in advance, but not more than 60. I just realized on mine I have a 10/60 there. That's probably not super helpful for y'all. Probably need some more words in there. Okay, voting. So generally you get one vote for one share, and shareholders may vote by proxy. A proxy is valid for up to 11 months. Proxy is valid for up to 11 months and is generally revocable unless the proxy document states that it is irrevocable and the proxy appointment is coupled with an interest. So that's a conjunctive test, right? So coupled with an interest. In interest for these purposes, what you're generally going to see could be a pledge or a contract for sale. An irrevocable proxy becomes revocable when the interest is coupled with is extinguished. Okay, so if it's a security on a loan, when that loan is repaid, it's no longer coupled with an interest. But you'll notice that it becomes revocable, so it's not automatically revoked. Okay, so bear that in mind. Next, a quorum. So a quorum is required for any action. A majority of votes entitled to be cast at a meeting constitutes a quorum. The quorum cannot be broken by a shareholder leaving. That's often tested as well. The required number from a quorum may be reduced from a majority to not less than 1/3. So while we're talking about meetings and voting, let's talk about cumulative voting. If cumulative voting is authorized, a shareholder may cast as many votes for directors as a shareholder has shares, multiplied by the number of directors to be elected. Cumulative voting encourages minority representation. Cumulative voting encourages minority representation on the board. The effects of cumulative voting can be defeated by specifying classes for directors or reducing the number of directors. Let's talk about voting arrangements. The first voting arrangement is a voting trust. Voting trust is just like trusts in the wills and trust type context. It separates legal and beneficial ownership, and shares are actually transferred to the trustee. The trustee is under a duty to file a list of participating shareholders with the corporation. Our next voting arrangement is the shareholders agreement. Shareholders agreements are private contracts which are specifically enforceable between shareholders. So I've seen this come up in two contexts. The first is which of these can be a secret arrangement. Voting trust has to be registered with the corporation, so it can't be secret, right? So shareholders agreement would be the way to go if you don't want anybody else to know about it. And the shareholders agreement is specifically enforceable. So a court would in fact tell people or mandate how people would vote, which is a little bit unusual. Okay, so now derivative actions. In order to bring a shareholder derivative action, the person must have been a shareholder when the transaction complained of occurred or have become a shareholder through operation of law. For instance, inheritance. The complaint in a derivative action must be verified. This must be verified and allege with particularity the demand made to get the board to act. This is known as the universal demand requirement.
What's the website?
Universal demand requirement. If the court finds that the board or advisory or special litigation committee made a reasonable investigation of the shareholder's issue and concluded in good faith that maintaining the action would not be in the best interest of the corporation, the action will be dismissed. Once brought, a derivative action may not be discontinued or settled without court approval. So next, fundamental corporate changes. In the event the corporation is undergoing a fundamental change, for instance, merger, sale of all assets outside the regular course of business, or a share exchange, consider who's going to be affected. The affected party is the party who gets to vote on the change and who may have appraisal rights. So when I say consider who's going to be affected, if Corporation X is buying Corporation Y, the X shareholders' rights, limitations, preferences don't really change. They're still X shareholders, right? But the Y shareholders, their interests are going to change fundamentally by now being owned by X. So in any of these types of questions, really break it down in your head to who's going to be affected. Okay, Barbary gives you whatever they're called now. Is it Barbary still? PMBR, Kaplan?
Yeah.
They give you a whole analysis of how to get through this, but fundamentally just consider whose rights change, okay? So with respect to fundamental changes, appraisal rights. So appraisal rights are not available if the shares are listed on the New York Stock Exchange or American Stock Exchange, or there are at least 2,000 shareholders, and 10 million in value. So again, it's conjunctive. Okay. The corporation must give shareholders notice of the existence of appraisal rights in the notice of the meeting. A shareholder wishing to assert his appraisal rights must deliver notice of intent to demand payment. If the action is affirmatively voted, the corporation must send notice of the approval within 10 days and give shareholders a form on which to assert their appraisal rights and make an offer of value. The shareholder must execute and return the form to the corporation with their demand of payment or accept the corporation's offer. If the corporation disagrees with the shareholder's assertion of value, it must submit the matter to the court within 60 days. And that's a hard 60 days, okay? So if you blow the time frame, you're out of luck. So our next corporate consideration, is centralized management. The management of the corporation is centralized in the board of directors. So the board of directors must be made up of individuals. A director must be at least 18 years old and is not required to be a Florida resident or a shareholder of the corporation. That seems to be tested pretty frequently too. They want to lead you down an analysis by which you're going to say, of course they have to be a shareholder of the corporation, but in fact they don't. So the director may be removed with or without cause. And a director may resign by delivering his written resignation to the board. The board sets its own compensation. So the board sets its own compensation, and this is not considered self-dealing, which is also frequently tested because setting your own compensation seems to be the very definition of self-dealing, right? All right, regular meetings of the board of directors may be held without notice of the purpose of the meeting, and a special meeting must be preceded by at least 2 days' notice. So preceded by at least 2 days' notice of the date, time, and place, and the notice need not describe the purpose of the meeting. So contrast that to your shareholders, right? Shareholders have to have notice of the purpose. Or in the notice of the meeting, they have to be told the purpose of the meeting. For any action to be effective, a quorum must be present at the meeting to vote on the action. And a quorum generally consists of a majority of the board But the articles may authorize a quorum to consist of less than a majority, but no fewer than 1/3. So just like with shareholders, with respect to quorums, okay? At least, generally a majority, but not less than a third. Directors must act in good faith. Must act in good faith with the care of an ordinarily prudent person in like position under similar circumstances and in a manner that he believes to be in the best interest of the corporation. So we've got two kind of interesting standards there that are often tested. The first is the care of an ordinarily prudent person. It's not ordinarily prudent business person. Okay. And the second is in a manner that he believes to be in the best interest of the corporation. So that's subjective. In making his decisions, a director is entitled to rely on the opinion of experts, so accountants, attorneys, officers, employees. And in making decisions, the director may consider the long-term prospects of the corporation, the interests of the shareholders, the social effects of the action taken, the communities in which the corporation operates, and the economy of the state and nation. A director is not personally liable for monetary damages unless the director failed by action or omission to perform his duties, and, so conjunctive again, such breach or omission constitutes a criminal act, the transaction from which a director derived an improper personal benefit, so in a derivative action, where the breach or omission constituted conscious disregard for the best interest of the corporation or willful misconduct, or where the breach or action constituted recklessness, or was committed in bad faith or with a malicious purpose. So our exception to centralized management is in a corporation of 100 or fewer shareholders, an agreement may be made to change the governance scheme of the corporation, even to get rid of the board. If such agreement is entered, it must be set forth in the articles, or made by unanimous agreement of the shareholders. An action by a director, which would otherwise be a conflict of interest, will not be improper if first, the relationship or interest is disclosed, and the contract is ratified without counting the vote of the interested party, although such interested party may be counted for quorum purposes, or the action is ratified by shareholders after disclosure, or the contract or transaction is fair. So the contract or transaction is fair at the time it was authorized. So liability for improper distributions. A director who makes a distribution which violates either the equity, insolvency, or balance sheet test is personally liable to the corporation to the extent that the distribution was improper. So not the entire distribution, just to the extent it was improper. So limited liability. The liability of a shareholder for corporate action is extremely limited. The shareholder is essentially obligated to pay first full consideration for shares.
Wait, what?
Full consideration. He must pay full consideration for his shares. And the veil of the corporation may be pierced, thus making the shareholder individually liable for the debts or liabilities of the corporation if the shareholder has participated in fraud or illegal conduct, which has led to the debt or liability. So that's corporations. So now let's jump into not-for-profits for a few minutes. So in not-for-profits, we've got articles with required content and discretionary content. So again, I would just memorize the mandatories. So your first mandatory is the name. The second is street address of the principal office. The third is a purpose statement. And then where it says statement provided, that should have been another bullet point. That's a typo. So that should be our fourth bullet point, is the statement provided method, or statement providing the method for electing directors, So notice here, importantly, that in not-for-profit, you have to have a purpose statement in your articles. Okay. So fifth, any provision limiting the corporate powers otherwise provided by statute. Sixth is the street address of initial officers and name of registered agent. And seventh is the name and address of each incorporator. Permissive content in the articles of a not-for-profit, names and addresses of initial directors, provisions regarding regarding regulation of internal affairs, the manner of termination of membership. So the manner of termination of membership, rights upon termination, transferability or non-transferability, and distribution upon liquidation or dissolution. A not-for-profit can be organized for any lawful purpose that is not for pecuniary profit. Pecuniary profit. With respect to distributions in a not-for-profit, a corporation may not make distribution to its members, directors, or officers, but may pay compensation. Distribution may, however, be made upon dissolution. Be careful with any compensation questions in a not-for-profit. Essentially what you're looking at is a corporation of similar size in the for-profit sector that has a similar amount of assets and does similar work. So somebody was challenging the director of Hospice of the Palm Beaches. I think the guy makes like $620,000 a year. It was found that in similar healthcare industries, hospitals, things like that, that was a reasonable salary. So despite the fact that they're a not-for-profit, he's entitled to that level of salary and it's not subject to challenge. Okay. A not-for-profit may purchase back its memberships if after the purchase, the balance sheet and equity and solvency tests are met. Now members, this chapter refers to holders of an interest as members rather than shareholders. Members have no voting rights, except those set forth in the articles. Liability is limited to dues, assessments, or fees. Interests are generally not transferable. Resignation of a member does not relieve the member from obligations that arose prior to his resignation. A member may not be suspended or terminated, a member may be suspended or terminated pursuant to a procedure that is fair and reasonable and carried out in good faith. With respect to directors, the board must consist of at least 3 individuals. So contrast that to your for-profits again, right? There's no requirement for a minimum number of directors. But in a not-for-profit, you have to have at least 3. So that's it for not-for-profits. Now we're into partnerships. A partnership is an association of 2 or more persons. 2 or more persons to carry on as co-owners a business for profit. A partnership is a separate juridical entity that can sue and be sued, can hold property, that is a pass-through entity for tax purposes. The partnership statutes are default rules. The partnership agreement is a governing agreement. However, a partnership agreement cannot first change any filing requirements.
Any what?
Filing. Can't eliminate access to books and records. And it can't entirely eliminate the duty of loyalty. So formation, a partnership is formed when the definition is met, regardless of the subjective intent of the parties.
Question.
Sure.
Can eliminate, but it can modify, right?
Absolutely, yeah, it can modify pretty severely. All right, so a partnership is formed when the definition is met, regardless of the subjective intent of the parties. The following factors are not by themselves sufficient to find a partnership. First, holding property as joint tenants. So holding property as joint tenants, tenants in common, tenants by the entirety, joint property, community property, or as part owners. The next, sharing of gross returns. However, where profits are shared, one is presumed to be a partner, unless the profits are received as payment on a debt for an independent contractor services or as rent. Partnership capital is made up of contributions by partners. Partnership capital is made up of contributions by partners. And property can be acquired by the partnership. Property is partnership property, if first acquired in the name of the partnership. Second, acquired by one acting in his capacity as partner. Property is presumed to be partnership property if it is purchased with partnership assets. Property is not partnership property if it is acquired only in a partner's name, even if the property is used by the partnership. The partnership owns partnership property. The partners do not own it as co-owners. With respect to agency, each partner is an agent of the partnership. An act of the partner in the ordinary course of business binds the partnership. An act of a partner outside the ordinary course of business binds the partnership if the partner acts with authority given by all of the partners, or such action is authorized in the written partnership agreement. Partner's liability. A partner is personally liable for all partnership obligations. However, there is no personal liability for debts incurred by the partnership prior to the person becoming a partner. A judgment against the partnership is not by itself a judgment against a partner. The judgment against the partnership may not be satisfied from a partner's assets unless there is also a judgment against the partner. Purported partners. A purported partner is liable where he represents or allows himself to be represented as a partner to any third party who relies on that representation. So partner rights and duties. Each partner has a partnership account. Each partner has a partnership account consisting of money and property contributed and distributions made by the partnership, less liabilities distributed and shares of partnership losses. Each partner has equal rights in management. Each partner can only use partnership property to benefit the partnership. Listen. Each partner is entitled to reasonable compensation. So each partner is entitled to reasonable compensation for services in winding up, but not compensation for services performed for the partnership. Decisions within the usual course of business are by a majority. Decisions outside the regular course must be unanimous. A person may only become a partner upon the consent of all the partners. The partner is not entitled to receive distributions in kind. Each partner has the right to access books and records, including the right to inspect and copy. So standards of conduct, loyalty. A partner must account for any personal profits. Must account for any personal profits received in connection with partnership business. A partner may not deal with the partnership in an adverse way, and a partner must refrain from competition. So must refrain from competition with the partnership. Now the duty of care, a partner can't act in a grossly negligent or reckless way or with intentional misconduct. Partner owes a duty of good faith and fair dealing. Actions by partnership and partners. A partnership can bring an action against a partner for breach of the partnership agreement or for violation of a duty owed, where the violation caused harm to the partnership. A partner can bring an action to enforce his rights under the partnership agreement or to enforce other rights under the act. A partner can only transfer his economic interests in the partnership, which means his shares of profits and losses and his rights to receive distributions, but not his interest in management. Dissociation, so events of dissociation. A partner can dissociate by giving notice. So he can dissociate by giving notice of his expressed will to immediately withdraw. A partner can dissociate upon the occurrence of an event specified in the partnership agreement. Partner can dissociate by being expelled. By being expelled by a unanimous vote of the other partners if it is unlawful to carry on with that partner or if the partner has transferred all of his transferable interests. So wrongful dissociation. Dissociation is wrongful if it is in breach of the partnership agreement or it's before the expiration of the term, a partner withdraws, partner is expelled by judicial order, or a partner is a debtor in bankruptcy. So the effect of a partner's dissociation, the partner's right to participate in management, the right to participate in management and conduct terminates. Partner's duty of loyalty terminates, but the partner's duties of care and loyalty continue for transactions occurring before the dissociation. A dissociated partner can remain liable on transactions occurring up to 1 year. to 1 year after the partner dissociates if first, the other party believes he was still a partner and did not have notice. However, the dissociated partner can file a notice of dissociation, and then he will remain potentially liable for 90 days. So now, dissolution. A partnership at will dissolves when a partner withdraws. A partnership for a definite term dissolves within 90 days of a partner's dissociation by death or wrongful dissociation. It dissolves where it is the express will. So it dissolves where it is the express will of all partners to wind up. Dissolves at the expiration of the term, and dissolves at the happening of an event specified in the partnership agreement. Dissolves on application of a party, and it is judicially determined that first, the economic purpose is likely to be frustrated, or it is not lawful to carry on with a partner, or it is not reasonably practical to carry on pursuant to the partnership agreement. The partnership continues until it finishes winding up. However, the partnership can waive its right to wind up and terminate the partnership if the partnership resumes business as though the dissolution never happened. The failure to wind up will not adversely affect the third party. All right, so limited partnerships. In a limited partnership, a person can be both a general and limited partner with his duties dependent upon which capacity he is acting. A limited partnership has a distinct existence, and a certificate of limited partnership must include first the name of the limited partnership. The name may contain the name of any partner, including a limited partner. And the name must include some indication of its limited status. It must include also the name and address of each general partner. Whether the partnership is an LLLP, and where there has been substantial compliance with these requirements, the document is effective when filed. So the records office. The LP must designate and maintain a designated office and a registered agent in registered office. The records office must maintain a current list showing the full name and street address of each partner and separately identify the general and limited partners. Must contain copies of filed documents, copies of the last 3 tax returns, and a copy of any partnership agreement and all amendments thereto. The partnership agreement governs the relations among the partners and between the partnership and partners. The partnership agreement cannot, first, vary the power to sue and defend in its own name. Second, vary the applicable law. Third, vary the maintenance and signing requirements. Fourth, restrict the right to information. Sixth, eliminate the duty of loyalty. So, eliminate the duty of loyalty of the general partner. However, it can identify specific types of activities that do not violate the duty of loyalty. Also, it cannot unreasonably restrict the duty of loyalty of the general partner. Limited partnerships, unlike general partnerships, can carry on not-for-profit activities. All right, contributions. The form of contribution can be any pecuniary benefit, including money, services performed, promissory notes, other agreements to contribute cash or property, and contracts for services to be performed. The obligation to contribute. So the obligation to contribute shall be in a record signed by the partner. Performance is not excused by death. So performance is not excused by death, disability, or inability to perform. So that would be a claim against the deceased partner's estate. Profits and losses are allocated on the basis of the value of contributions. All general partners are jointly and severally liable. Yeah.
There's no joint and several liability for that.
There still is under the Florida statutes and partnerships. The legislature hasn't resolved that. So for partnership purposes.
Just ignore the other.
Essentially. Yeah. There's supposed to be some revisions to the partnership code, but they've been in the works for 5 years. And it doesn't appear to be a popular area to work in. So for now, we have joint and several liability in the business entities realm. The limited partnership itself may be liable for loss or injury occurring as a result of the wrongful act or omission or other actionable conduct of a general partner acting in the ordinary course of activities. The limited partner's liability, the obligations of the limited partnership are not the obligations of a limited partner, whether in contract or tort, even if the limited partner participates in management. Rights of partners, the limited partner has no power to act for or to bind the limited partnership. A limited partner can inspect and copy documents after 10 days' notice. And no particular purpose is necessary with respect to required information. With respect to information on the state of activities and financial affairs of the LP, it must have a purpose directly connected. So it must have a purpose directly connected to the limited partner's interest as a limited partner. The limited partner must make a request describing the records sought with reasonable particularity. And the information sought must be related to the purpose described. Okay, management rights of general partners. Each general partner has equal rights in management. Decisions are generally made by a majority of general partners. However, some decisions require the consent of all of the general partners. These include amendments to the partnership agreement, amendment to the certificate of limited partnership, admitting a new general partner, admitting a new limited partner, expelling a limited partner, dissolving the limited partnership, or approving a merger or conversion. Each general partner has the right to inspect required information and other information relating to the activities and financial condition of the partnership. With respect to distributions, a limited partnership may not make a distribution first in violation of the partnership agreement, or if the equity and solvency test is not met, or if the balance sheet test is not met. Just like a director in a corporation's context, a general partner who consents to a wrongful distribution is personally liable to the LP to the extent the distribution was wrongful. So dissolution and dissociation, you must file a certificate of dissolution. The certificate must include the name, the date of the initial filing, the reason for the current filing. A limited partnership is dissolved upon first an event specified in the partnership agreement, or the consent of all general and limited partners. Notice that's unanimous. With winding up, after dissolution, the LP continues only to wind up, which includes discharging its debts, filing a statement of termination. With respect to derivative actions, a partner need not first make a demand. So contrast that to our corporations where we had a universal demand requirement. So a partner need not first make a demand on the limited partnership if he can prove the futility of making a demand. We don't have demand futility in the corporate context. An annual report must be filed. And with respect to erroneous belief, if one believes in good faith that he is a limited partner, he is not liable for any obligations of the limited partnership simply by making an investment, by receiving distributions, or by exercising the rights of a limited partner. He may be liable to a third party who believes he is a partner, and this belief is in good faith. All right, limited liability companies. So I think you guys are far enough down the road now that the new LLC Act is pretty much all that's going to be tested. That was effective January 1st, 2014. LLCs could previously have a managing member. A what? Managing member. This concept has been deleted, and the term has been clarified so that it no longer makes the LLC manager managed. The general default rule is that the LLC is member managed, and all members have apparent authority to bind the LLC. The definition of member has been changed to permit a member to have voting or management rights without being entitled to any distributions. Next, the term transfer. So the next blank is transfer. It's more broadly defined to apply to any assignment, sale, gift, encumbrance, transfer by operation of law, or other transfer of a member's interest. A transferable interest is limited to the right to receive distributions. LLCs are governed by an operating agreement to which the law of contracts generally applies. The operating agreement can be written or oral. Note the term operating agreement presupposes the existence of the entity. So pre-formation agreements are not operating agreements. The LLC itself can enforce the operating agreement. And the statutory provisions regarding operating agreements include the following. Operating agreements are primary in evidencing the relationship of the members to each other and to the LLC, the rights and duties of managers, and the activities and affairs of the company. The LLC statutes are default rules. There are non-waivable statutory provisions, some of which we'll address below. There are certain provisions authorized unconditionally, and some limited to being, quote, not manifestly unreasonable. So your standard for a lot of things in the LLC context is not manifestly unreasonable. We're going to define it and consider it further in a bit. And it confirms that the operating agreement may set forth specific penalties or consequences for failure to comply. Non-waivable provisions in operating agreements. First, judicial dissolution. Second, unreasonably restrict the right of a member from bringing direct action against the company, another member or manager, or maintaining a derivative action. Third, unreasonably restrict the inspection and copying of records. The operating agreement may not exonerate a person from liability for conduct which involves bad faith, willful or intentional misconduct, or a knowing violation of the law. The not manifestly unreasonable standard is applied with respect to the elimination or alteration of the duties of loyalty, care, good faith, and fair dealing. A court must decide as a matter of law whether a term is manifestly unreasonable. The court may invalidate only if it is readily apparent that first, the objective of the term is unreasonable. Essentially, if the term is unreasonable, means to achieve the provision's objective. The operating agreement is generally not subject to any statute of frauds other than obligations relating to capital contributions. With respect to formation, an LLC must have at least one member for its formation. The name, address, and identity of the registered agent. The name, address, and identity of the registered agent must be included, and the operating agreement should indicate whether the LLC is managed or managed. A person may bind the LLC in any of the following ways: as an agent of the LLC, by grant of authority in the articles, a grant of authority pursuant to a filed statement, or having the status as an agent, authority, or power. In member-managed LLCs, the members have statutory apparent authority. So with respect to statements of authority, the new act allows LLCs to file statements of authority. And file statements of authority with the state, which give record notice to third parties of a person's power to bind or limitations of same, the LLC. Statements of authority. With respect to real property, the statement of authority must be recorded in the local jurisdiction. Unless canceled, the statement of authority is canceled 5 years after the date of the statement of authority. That's an automatic cancellation. Members, how to become a member. First, the operating agreement can provide requirements. The operating agreement can provide requirements. Operating agreement can provide requirements. Admission may occur as a result of a merger, interest exchange, conversion, or domestication, or with the consent of all other members. The old statutes required a majority in interest. Where an LLC is being dissolved and the LLC has not had a member for at least 90 days, a member may be admitted by consent of the majority in interest of the transferees. Contributions can be cash, promissory notes, services performed, contracts for future services. Liability for contribution must be in writing. So it must be in writing and signed to be enforceable. Once enforceable, performance is not excused by death, disability, or inability to perform. Distributions are made on the basis of the agreed value of contributions. So the agreed value of contributions. And they are limited by balance sheet and equity and solvency tests, just like our corporations. Liability for improper distributions, like corporations, but a member of a member-managed LLC will not be personally liable if the operating agreement expressly relieves him of the authority and responsibility to consent to distributions. So you would see that if it's manager-managed and managers are the ones who make the distribution decisions. Persons who knowingly received an improper distribution may be liable for contribution. Any action to recoup improper distribution must be commenced within 2 years. Sorry? Okay.
Sorry.
Nature of the membership interest, the transferable interest. Transferable interest means the transferee's rights to distribution, whereas the word interest under the previous act referred to distribution rights, voting rights, management rights, and any other member rights under the Articles or statute. A transfer of a transferable interest does not cause the transferor's dissociation. The transferee is entitled only to receive the distribution. So only to receive the distribution the transferor would have received. The transferee is not entitled to participate in management. It is not entitled to participate in management or access records. With respect to voting, in a member-managed LLC, each member has the right to vote proportionate to his then current percent interest in profits. The voter consent of a majority in interest versus per capita simple majority is required. So we've got some situations in which unanimity is required, and the first is an amendment to the Articles. Questions of admitting a new member, expelling an existing member, or dissolution. If a member has transferred his interest to a person who is not a member, the transferring member is still entitled to vote. Proxies may be appointed. In a manager-managed LLC, each manager has equal rights in management, and an affirmative majority vote is required. An affirmative majority vote is required. Unless the action is taken without a meeting, then unanimous consent is required. An act outside the ordinary course requires unanimity. So dissociation in this context, in addition to dissociating due to bankruptcy, dissolution, and winding up, or the occurrence of an event stated in the Articles of operating agreement, a member can also dissociate by voluntary express will and involuntarily by expulsion. A member can dissociate wrongfully or rightfully at any time. A wrongful dissociation can incur liability to the LLC and existing members. Expulsion can occur as prescribed in the operating agreement, or if the members unanimously agree to expel. So unanimously agree to expel. Expulsion by unanimous agreement is only available where the LLC cannot lawfully carry on with that member. The member has transferred his entire transferable interest, or the member to be expelled is an entity which has been dissolved. So creditor remedies in a multi-member LLC, a judgment creditor can obtain a charging order. Against the judgment debtor's interest, so that the company would pay the judgment debtor's distributions to the judgment creditor to satisfy the judgment. In a single-member LLC, where the judgment would not be satisfied within a reasonable time, the court may order the transferable interest, to be sold at foreclosure. The purchaser acquires the entire LLC interest, not just the transferable interest, and becomes the sole member, and the judgment debtor is deemed dissociated. That's why I don't like single member LLCs.
And would he be liable or not? The
Liability would continue, because it's a wrongful dissociation. Yeah. So for events occurring prior. With respect to management, member managed is the default designation. In a member managed LLC, all members have management authority. A member is not entitled to compensation. So a member is not entitled to compensation, except for services performed in connection with winding up. In a manager-managed LLC, managers are chosen with the consent of members holding greater than 50% of then current interest in profits. A manager will continue to act as manager until a successor is chosen, or the manager resigns, is removed, or dies, or if the manager is an entity and the entity terminates. So duties and standards, loyalty, this includes accounting to the LLC and holding as trustee and winding up, the use of company property, or appropriation of company opportunity. Also includes refraining from dealing with the company in an adverse way and refraining from competition. With respect to care, you cannot engage in grossly negligent, or reckless conduct, willful misconduct, or a knowing violation of the law. Conflicts of interest. A manager or member does not violate a duty solely because his conduct furthers his own interest. A transaction between the LLC and its members or managers, or another entity in which its members or managers have an interest, is not void or voidable. So it's not void or voidable because of that relationship or interest. Because the members or managers are present at a meeting at which the transaction was authorized or approved, or because their votes were counted for the purpose. If the transaction is fair, to the LLC, neither equitable relief, damages, or sanctions are available. Fair means the transaction considered in its entirety is beneficial to the LLC and members. Records, if member managed, each member has unlimited access to information concerning the company's activities and affairs, financial condition, and other circumstances that the company knows and is material to the proper exercise of the member's rights and duties under the operating agreement. Unless the company reasonably believes the member already knows the information. The company shall furnish on demand other information concerning the company's activities and affairs, financial condition, and other circumstances, except to the extent the demand is unreasonable or otherwise improper. The duty to furnish requested information extends to any member to the extent the member knows any of the info. If manager managed, each manager has the same right of access that inure to the members. A member can inspect and copy the current lists of names and addresses of members and managers, a copy of the then in effect operating agreement, a copy of the articles, 3 most recent tax returns, and the 3 most recent year's financial statements. A member may seek other information if the information is sought for a purpose reasonably related. So reasonably related to the member's interest as a member. The member makes a demand describing with reasonable particularity. This should sound familiar, right? Reasonable particularity, the information sought and the purpose of seeking the information, and the information sought is directly connected to the member's purpose. The company has 10 days to respond. That's my business entities lecture. Do you have questions? I can hang around for a bit.
Good question.
Yeah.
My EA class was a lot more
Yeah.
complex and perfect, so is this the only thing that I'm gonna have to focus or?
From my review of the questions, this would get you past a majority of the questions. That's why I try to make it bare bones so it gets you to where you need to be, but it definitely is not a specialization in business entities. I we would be here 3 days for that, so.